right. Hi, everybody. Molly Duplashane, Executive Director of Excise and Licenses. Thank you for joining us at our March 2025 marijuana industry check-in. We haven't done one of these in a little while, so excited to see many of you hopping on today. We have a little bit of an agenda, so we can go to that side and I'll just walk through what it is that we are going to be talking about today. We have some just general updates for you today, things we like to remind you about this time of year with 420 coming up, but also I think just some good general reminders for any time of year as well. And then we'll also walk through a presentation of a draft ordinance that we'll be taking to City Council next month. And there's a couple of changes in there that I think you'll all be interested in. And then we'll also, we have Mark Slaw here, and so he will walk through the social equity technical assistance program and some updates that are happening with that program. And then we'll close out with some information and reminders about our Cannabis Cares program. And then we'll also be leaving some time at the end for questions and comments. So that's what's on the agenda today, and I will just put in a plug. If anybody has anything else that we want on future industry check-in agendas, feel free to ping us on those as well. So, and I'll now pass it off, I believe, to Abby.
And I will pass it off to Robert.
Oh, sorry.
To
Robert.
provide some updates on or some reminders for 420.
Thank you very much. All right, yeah, I had a Zoom emergency there, but I made it on time. Thank you all very much. Sorry I was late. Would like to talk about some reminders for 420 and beyond, really, for the event on April 20th, but these things all apply to the industry in general all the time. Again, I'm Robert Darrow. I am the investigator supervisor with Denver's Department of Excise and Licensing. So you have a booth at the event or a marijuana business, you might be wondering what is allowed when it comes to advertising. Marijuana businesses can distribute apparel, consumer goods, paraphernalia containing your business name, logo, and distinct design or features, but not really any other things, no other advertising of the marijuana business. Consumer goods are goods primarily used for personal, family, or household purposes, but do not include vehicles. And so you might be asking yourself, well, what is this? And what we see in the field generally, or what we see people using, is usually T-shirts, hats, water bottles, keychains, lanyards, lighters, similar items to that. Also, generally, any advertisement contained within a newspaper, magazine, or other periodical of general circulation is permitted. So what's not allowed? Any advertising visible to members of the public from streets, sidewalks, in a park, or other public place, including advertising using any of the following. So that would be billboards, outdoor general advertising devices defined in the zoning code, signs mounted on vehicles are not allowed, handhelds or portable signs, so spinners, sandwich boards, or any handbill, leaflet, or flyer distributed in a public place, left on cars, or posted in public areas. So those are the items that are not allowed. All right, some general advertising questions that we get when we're at the 420 event, or just doing inspections in the field. And just as a reminder, we are at the 420 event, so we will be walking around looking for advertising and just doing education with folks if we see anything that's against the DRMC. So, but what questions we often get are, what if it's on private property? Well, the event on April 20th isn't, but if you are at a private event, if you're at an event on private property, excuse me, marijuana businesses may display signage or advertising so long as the advertising is not visible to the public from a public place. Can a marijuana business advertise at a charitable event that the business is sponsoring? And the answer to that is yes. If it's purely incidental to sponsorship of the charitable event, it is permitted. It can include the name, logo of the marijuana business in the materials, such as like programs and maps for the event, or temporary signs and banners displayed at and during the event. Billboards are not allowed. Billboards really aren't ever allowed in the city and county. So, and you might be asking yourself, this is great, where can I find this information? Everything I just went over is in Denver's advertising rules found in section 6-224 of the Denver Revised Municipal Code. Excuse me, and you can also refer to the Colorado Marijuana Enforcement Division for state requirements related to advertising. Just a couple more reminders that we have after that. Giveaways and consumption. Sometimes we get questions about giveaways and consumptions. I think everybody knows this by now because we don't see this violation at the 420 events any longer at all. So, really, so and we'd like to keep that up. But open and public consumption, open and public consumption of marijuana is prohibited. That we do see at the event. But really what I was talking about was sales outside licensed marijuana businesses, and giving away regulated marijuana is prohibited. It always has been. We do see the public consumptions at the event, but it is and always has been prohibited. Thank you very much. I'll hand it back over to Abby.
Thanks, Robert. So hi, everyone. I'm Abby Soyson. I'm a senior policy analyst with the Department of Excise and Licenses, and I'm going to start by going over some proposed updates to the Denver Marijuana Code. So what we're going to go through are some proposed changes to our local marijuana code. All of these changes are currently proposals and still have to be voted on by Denver City Council. So none of these proposals have been adopted yet, but we will be bringing an ordinance to City Council in April for them to consider these changes and vote on them. And the draft ordinance that we'll be going over was shared through our marijuana bulletin that went out yesterday. So if you're signed up for our marijuana industry bulletin, we sent out a bulletin yesterday reminding everyone of this meeting. And you can also find the draft ordinance linked in that bulletin as well. So the first proposal that that you'll see in the ordinance is to update the social equity criteria in Denver's marijuana code to align with the state social equity criteria. So for some history and background, in 2020, the state legislature adopted a definition of a marijuana social equity applicant. And then in 2021, when Denver was adopting our social equity program at the local level, which reserves most of our marijuana license types exclusively for social equity applicants, when the city was adopting that program, we also adopted the state's definition of a social equity applicant. So at the time, those definitions were in alignment with one another. Then in 2024, the state legislature passed a bill modifying the definition of a social equity applicant. And those new criteria to qualify as a social equity applicant became effective February 1st of this year. So beginning February 1st, 2025, Denver's local criteria are different than the state criteria. That change at the state level didn't impact local criteria. So the issue that we have is that state and local social equity criteria no longer align with one another. And so that means that there may be folks who qualify as a social equity applicant at the state level, but not in Denver, or vice versa. So that could lead to some confusion and just make it a little bit more difficult for social equity applicants to take advantage of both state and local programs for social equity businesses. Our proposed solution in the ordinance is to revise Denver's definition of a social equity applicant to mean a person with a valid finding of suitability as a social equity applicant from the state licensing authority. So this would mean that if an applicant got a finding of suitability from the Marijuana Enforcement Division that says they qualify as a social equity applicant, they could apply for their new license in Denver or for a transfer of ownership of a license in Denver as a social equity applicant using that finding of suitability rather than having to qualify under a separate set of criteria here locally. And so the impact of this change is that it will, we hope, prevent some confusion between state and local processes and streamline the licensing process so that applicants only have to be qualified by the Marijuana Enforcement Division, and then they can use that qualification to qualify as a social equity applicant here in Denver. And then this will also just ensure that social equity applicants can take advantage of those programs and financial and technical assistance that's available at both the state and the local level. So for everyone's information, this is kind of a high-level look at how the criteria have changed. So Previously, an applicant was required to be a Colorado resident at the time of application. Beginning February 1st, 2025, that is no longer required. The applicant cannot have owned a marijuana license that was revoked, and the applicant has to hold at least a 51% ownership interest in the business. Both of those criteria are still required. And then a new requirement is that the applicant cannot have been or cannot be an owner of more than 3 marijuana store licenses or cultivation licenses at the time of application. So that's a new requirement that's in place beginning February 1st. And then there are a few different ways to qualify still. A social equity applicant would have to qualify under one of those criteria listed, but they have changed a little bit. So one of the ways to qualify is based on where you lived for a certain number of years during a certain time frame. That has been modified from the original criteria. Having a marijuana offense is still a way to qualify, but how you qualify using your own marijuana offense or a family member's marijuana offense has been modified as well. Previously, applicants could qualify using their income in the year prior to application. That is no longer an option as a way to qualify. And then a new option for a way to qualify is having received some type of public assistance. That's a new option for qualifying. So I won't go too much into the weeds about the different criteria, but if you would like more details about the social equity criteria, what they used to be, what they look like now, definitely encourage you to visit the Marijuana Enforcement Division's website. They have a lot of great information and details, as well as some resources to help you figure out if you might qualify and what you might need to present to the state licensing authority to demonstrate that. The second proposal that you will see in the ordinance is really meant to provide a little bit of support for some of our stores that are medical marijuana only stores and are located within 1,000 feet of an existing school. So currently the Denver Marijuana Code prohibits us from issuing a medical or retail store license within 1,000 feet of a school, childcare facility, alcohol or drug treatment facility, or another marijuana store, except that a retail store license can be issued at the same premises as an existing medical marijuana store, even if it's within 1,000 feet of a childcare facility, an alcohol or drug treatment facility, or another marijuana store. So the solution that we are proposing in the ordinance is to exempt applications for a retail marijuana store license at the same location as an existing medical marijuana store from the application of the proximity requirement to schools. And that will allow legacy medical marijuana stores that are located within 1,000 feet of a school to add a retail store license to the same location. So there may be some, a handful of stores that are located within 1,000 feet of a school because, maybe they existed there prior to the proximity restrictions being put into place, or maybe a school opened after that store was already existing. But whatever the reason, a medical marijuana store located within 1,000 feet of a school under this proposal would be able to add a retail store license to that location. And that wouldn't create a new store location. It would just allow them to sell retail marijuana at that same store location. And now I will hand it over to Erica to talk about hearings.
Hi, everybody. For those of you I don't know, I'm Erica Rogers. I'm the policy director here at Excise. So I'll talk to you a little bit about the third change you'll see in the proposed bill, and that's around discretionary hearings. So a lot of you may know that certain marijuana applicants have to undergo a mandatory needs and desires hearing as part of their application process. This is a requirement in our local code for marijuana stores, as well as hospitality and sales locations. These are all licenses that are currently reserved exclusively for social equity applicants through 2027. However, state law does not require a needs and desires hearing. This is a requirement that was mirrored after the liquor license needs and desires hearing requirement that we have statewide for liquor licensees. Some of you may know that last year at the legislative session, the Colorado General Assembly removed that mandatory requirement for those liquor hearings and allowed local jurisdictions to determine needs and desires through means through a hearing or not through a hearing, but at any rate left it up to the local jurisdiction's discretion. So in Denver, we'd like to move toward that discretionary hearing model where it would still be an available tool if we had, a debate over needs and desires in a particular neighborhood and a hearing was warranted. However, for the majority of our applicants, these hearings are unopposed, and that means no one shows up to testify in opposition to the application. And so we're looking to streamline our process here by removing those steps that have the dotted line around them. So the issue obviously is that we don't want our applicants to go through a hearing process that might be costly and add time to their application process if there isn't any opposition in the neighborhood. So we're going to remove the shall from the requirement in our local code, allowing us to set the hearings on a discretionary basis. The basis would likely look something along the lines of, an application has been submitted, notice would still go out to the neighborhood, and the neighbors would have an opportunity to request a hearing. This would look similar to our process for special event liquor permits, which we've done for many, many years and has seemed to work well. So we're hoping that the impact would be that, the 95% of these unopposed hearings would be able to move through their application phase more quickly, and that our applicants would be able to save money associated with obtaining a lawyer. Usually this costs applicants anywhere between $5,000 and $10,000, even if the hearing is unopposed. The other thing that we're hoping to achieve through this change is to encourage RNOs and businesses to resolve issues prior to the application, so that when that application gets submitted, the RNOs will already know that it's coming, reducing the need for them to request a hearing because any of their concerns may have already been addressed through a conversation with that applicant. All right, I'll pass it over to Kelly, who will walk you through the fourth change you'll see in the draft bill.
I'm Kelly Abrams-Rivers, EXL policy analyst. I'm going to be walking you through proposal number 4, which is our digital communication option. The issue here is that the department is required to send final decisions for marijuana store licenses to applicants via certified mail, and customers often prefer digital communications. Our solution to that issue is to remove the requirement in Denver's marijuana code and send final decisions via certified mail, but allow customers to opt into digital communications. We're hoping that the impact wouldn't be immediate. However, if the requirement in state law is also removed, EXL could provide more convenient communication options for customers. So again, this wouldn't be immediate until state law removes that requirement.
All right, thanks, Kelly. All right, so the fifth change that you'll see in the draft bill relates to court-appointed receivers. This is an issue that came to our attention in the realm of marijuana licensees, but this change would actually be to Chapter 32, which is our general licensing chapter, and it would apply to all of our licenses, not just marijuana. However, the issue that we've seen in the context of marijuana licenses is that sometimes court-appointed receivers of marijuana licenses are unable to take certain actions related to that license due to restrictions in our code or a lack of language or a lack of process. And so our receivers are find themselves in an odd situation where maybe a court has told them, you must take these kinds of actions, and our code doesn't permit us to accept their action on behalf of that license. So you'll see a change in Chapter 32 to allow receivers to act on behalf of a licensed business so that they can comply with those court orders. This would also trigger some rulemaking. It wouldn't just be an ordinance change. We would have to fill out some of those internal processes through that rulemaking process. So that would be separate and after if council were to make this change. But the idea being that we would be able to streamline that receivership process, both for the businesses and the receivers operating on their behalf, and ideally allow them to wrap up their proceedings and their court-ordered actions more quickly without confusion. All right, so we've gone over 5 different proposals. They're all in one draft bill. Like Abby said, it's linked in the bulletin that you got, reminding you about this session. It'll also be on our website. We'll send out a little reminder, we'll send out a summary bulletin after this. You'll be able to watch a link to this video if you want to go back and rewatch any of those descriptions. It'll also have a link to our website where we'll post the draft language. Like Abby mentioned, we'll be presenting these 5 changes at the City Council Business Arts Workforce and Labor Committee, BIZ for short, on April 16th. The Marijuana Bulletin will go out with information about how to participate in person or via Zoom, or if you'd like to watch on Channel 8, you're welcome to do that. However, if you have comments or questions or other ideas related to these proposals, you can email us ahead of April 16th at exlpolicy@denvergov.org. Like Abby mentioned, none of these will go into effect until and unless they are adopted by City Council. And that requires both a first reading and a second reading, and then it would be sent to the mayor for final approval. So again, we're still kind of in the brainstorming phase and would love your feedback at that email address all the way through the process. All right. With that, I'll kick it over to Mark Slaw with iComply to walk us through some information about our technical assistance program here in Denver.
Thank you so much, Erica, and thank you all for your work, especially regarding streamlining of many of the things that social equity applicants face. As a lot of folks may or may not know, Denver only issues new licenses out to social equity for the foreseeable future. And we've been tasked actually by another Denver agency, DEDO, or the Denver Economic Development Office, to create a program to support and assist social equity applicants. For those of you that haven't seen, this is our Cannabis Entrepreneur Technical Assistance Program, or what I like to call the Denver Social Equity Program. There are some funds that have been reserved for us to administer this program and to help people establish new brick and mortar businesses within the city of Denver. So this assistance program isn't available for delivery or transport or anything that doesn't have a brick and mortar like a mobile hospitality, but it is available for everything from lab testing to marijuana infused products manufacturers to cultivations to dispensaries and of course brick and mortar hospitality licenses. In this program, we are going to be providing tens of thousands of dollars in assistance for our social equity participants that qualify for the program and participate. This looks like personalized expert guidance and indeed putting together project plans, linking them up with a lot of our ecosystem members that are in the construction space to do design plans, engineering plans, floor plans, all of the things needed to sort of navigate the Denver Building Code process, including architectural plans. And of course, sort of building out the business itself while we're building out the facility. So things like access to resources in the form of standard operating procedures, checklists, those project plans, and sort of one-on-one guidance with companies like ourselves. We've been around in the cannabis industry since 2011, focused primarily on compliance, and have built a lot of the operational compliance out there in the space. So we're here to really help streamline the process for social equity folks and to get their business doors open. That's the goal of the program. What we realized early on in the program is there's a bit of a gap between sort of the traditional world of business and the social equity community and maybe the legacy market that people came from. And we realized that there's a real need to really bridge that gap and to bring folks up to qualification standard for this program. Because the eligibility requirements of the program do require that folks are qualified as social equity and that they have a valid business. That means registry with the Secretary of State, IRS FEIN numbers, and of course any operating agreements that are out there showing that they have their business partners and that they also have sufficient capital. And these last two are some of the more challenging ones for any business owner, let alone for social equity businesses. Things like sufficient capital, showing that you have your capital expenditures, your operating expenditures outlaid, that you have a plan for your business, and that you have enough money to execute that plan, has been probably one of the larger barriers. And of course, getting a physical location, an LOI or a lease. But many of our participants in our prep program, getting prepared for the program itself, are able to meet these requirements and are ready to go into business. And we're helping them hone in utilizing tools like AI and financial models we're providing, business planning models, slide deck models for pitch decks to be able to get folks really ready for this program. And so if you have sufficient capital, physical location, valid business, and your social equity, the program is here to help you. If you're looking to maybe partner with social equity, there's always going to be a need for capital and expertise and guidance from good business partners as well. So I don't think this is just a program of value that is offered for social equity applicants, but perhaps for existing operators as well that are looking to expand their footprint or their brand, or take some of that excess cannabis that has not enough retail outlets and be able to partner up with social equity in order to expand your footprint within the city of Denver through the means that are available to do so. So I'm more than happy to talk about that and be able to present business plans, pitch decks, and other work that our social equity participants are doing now. And here you can also see just sort of the courses that we've done in our prep program. We have recorded sessions starting with sort of these same qualifications. So if you have any questions or you want to learn more about the program, this is a great place to start. We also then dived into capital resources and most recently into business viability, planning, support, and operations. And here pretty soon at the end of the prep program, we'll be covering the real estate process on April 3rd. And you can still register for that Zoom call here live to be able to participate, get caught up with the program, and learn more about the proof of sufficient capital requirement, as well as the real estate process and the proof of possession of premises that's required for the program. And we'll be helping folks get ready for that program application on our very last session on April 29th. I know 420 is a busy season for everyone, but this is a great opportunity to really hone in on these social equity businesses and to learn more about the program. And come May 1st, we'll be opening up the second round of our programming with the application period ending on June 19th. So by this summer, we should have a few participants in the program and be working towards getting applications in, all of the design plans, architectural plans, and everything that goes into navigating the Denver building and code process. And so we're really excited to continue to work we've done so far. We've had nothing but glowing reviews from our prep program participants so far. So if you have any comments, questions, or would like to learn more, feel free to reach out to us. Our email is on our DIDO program webpage, and of course, to learn more about the program itself. And I'll be here and available tonight as well if anyone has any questions.
Awesome. Thank you so much, Mark.
Thank you.
Okay. I am going to hand it back over to Molly to talk a little bit, just a few notes about our Cannabis Cares program and some resources that are available.
Yeah, so we just wanted to remind everybody about the Cannabis Cares program and make sure that everybody is thinking about it and considering participating in it. So the Cannabis Cares program is a program, an incentive program that gives businesses the opportunity to earn badges for your work within the community or towards a priority area that can make a positive impact within the community. And so some of the information that we have on our website will really guide you through ways to participate or get recognized through this program. So you can go to the website and find things like some of the eligible activities that you can do to work towards earning one of the 5 badges. We also include on our website some information around nonprofits and community groups that are interested in working with cannabis businesses. So again, that's a great opportunity to identify groups that you would be able to work with to participate or engage in activities that could help you earn a badge. We also list on our website businesses that have earned one or more of the badges, including Cannabis Cares champions and advocates. So advocates are businesses that have earned 3 badges, and champions are ones that have earned all 5 badges. And then finally, we also list social equity businesses. So one of the badges is a social equity business. And so we all make sure that we list those on there so that the community can look at which businesses they would like to patronize and go to and can see which ones are social equity businesses or which businesses have participated in the program and have earned those badges. So just encourage you to check out the website and see if there's different activities or different badges that you would be interested in earning. And we do just want to recognize that we do have 3 businesses that have earned that Cannabis Cares Champion badge. So that means that they have received a badge in all 5 of our priority areas. And those are 2 locations of Jars Cannabis and Standing Akimbo as well. So definitely check those locations out and make sure that you recognize that they have done the work to earn all 5 of those badges. And I believe that gets us to our question and comment section, which I'll let Abby facilitate us through.
Yeah, so we have plenty of time for questions and comments. I know we presented a lot of information today, so definitely want to get your feedback and clarify anything that might have been confusing. So to ask a question, you can click the raise hand button at the bottom of your Zoom window, and then you'll be promoted to a panelist. So you have to accept the promotion in Zoom and then unmute yourself in order to speak. We just ask that you limit contributions to 2 minutes just to make sure that we have plenty of time for other speakers. And you can also email any written comments or questions to exlpolicy@denvergov.org. And then, as always, you can find more information at denvergov.org/marijuana-info. So if you have a question or comment, feel free to raise your hand. Oops, I just raised my hand as an example. And I'll go ahead and promote you.
I see we've got, I've answered one question in the Q&A box in writing, but we've got another question from a participant asking about if the city council finds the proposed ordinance amenable, how fast could the mayor sign the ordinance? And that's a great question. So typically I'll try to find the resource on city council's website and drop it in the chat, but typically there's a process where the committee will hear the ordinance, take feedback, and they will vote whether to advance that draft to the full council. Sometimes they send it back with some requests. Sometimes you have to come back to the committee. Usually it's just one appearance. But once it goes to the full council, it would be not 1 week later, but the following Monday. So almost 2 weeks after committee, it would go for first reading and as an introduced bill, excuse me. And then the following Monday, it would be read at second reading, and that's where they would take the vote. Sometimes they ask additional questions at that point, and then it would be sent to the mayor's office after that second reading. So he usually signs or vetoes bills within a week of council voting on them. So that timeline, like I said, there's a graphic that depicts that process on the city council website. I'll drop that in the chat. But we would be looking at early May for signature if there weren't any delays.
All right. We have a question or comment from Rachel Ardenoy. So Rachel, I'm going to promote you to a panelist.
Can you hear me okay?
Yes.
Okay, that just resulted in a new Zoom window opening. I think the question is for Erica. You were talking about the potential change or the proposed change for the needs and desires. So I was just trying to get a sort of a read on like how that's going to impact the time frame for those licenses to get to move to signature card phase. And so is it? I'm not sure if I caught this right. Are we thinking that we would still be posting notice at the property for a certain amount of time? And then by the end of that, like, let's just say it was the 30 days like we currently do. If you didn't get any like written or reached out responses asking for a hearing from a third party by the end of the notice hanging on the property, then there wouldn't be a further waiting period, kind of like, because like with a hearing, we have the 30-day notice time, and then sometimes it's a 30-day at a minimum time from the hearing to the hearing officer's opinion to approval and then signature. So I'm just thinking like, is this going to cut down maybe 2 months of the process of getting to the signature?
Yeah, that's a great question. And especially because I think for those who are less familiar with the legislative process, who might be on the call, that's not something you'll see in the draft ordinance because it's not something that needs to be set in ordinance. It will be left to kind of department policy. And we are looking at a system whereby, for example, let's say an applicant has a good neighbor agreement with an RNO that where they're locating. This is pretty common for both liquor and marijuana. Typically that would get introduced at a hearing. However, because the applicant will still need to show, right, like the need and desire, they would just submit that as part of their application. And so, yes, your instinct is spot on that rather than receiving a notice of hearing that goes out to the council member, that goes out to the RNOs, that goes out to the applicant and any other known parties in interest, it would instead be a notice of application. And so if there were petitions that were collected or letters of support, maybe a good neighbor agreement or a letter of non-opposition or support from a bid or an RNO, that would all get included in the application. And there would be that application posting period, and that would be the time during which community members could request a hearing. And if no hearing was requested, or say, you know, somebody requested it, but they live on the other side of town, they're not a party in interest, that applicant would then move directly into, you know, inspection phase where they would be able to fill out their inspection card and get that license issued.
Well, thank you so much. And then just sidebar, I know this is for marijuana, but are we anticipating that's going to be the same process for liquor? And like, I'm thinking too about if people are wanting to do, you know, it might be a little late by then, but like modifying their premises to allow outdoor seating to, you know, an outdoor serving or just modifications of premises for liquor, sort of avoiding that whole process too.
I think we would look to have a similar process for liquor and for marijuana to keep it, you know, to keep parity in that hearing process. We wouldn't want to create different standards. You know, that said, if there are different state rules that influence or local rules that influence when a hearing may be required or when something, I'm thinking of a modification, may be considered material and substantial, those have different, you know, standards, yes, factors. So I think, great, we would try to be as across the board equal as possible, but with special note for those particular circumstances. Did that answer your question?
Absolutely. Thank you very much.
Yeah, you're welcome. I see another question in the Q&A box about needs and desires hearing. So I'll just take that one as well. And that asks, do we think the needs and desires hearings will be eliminated, or is there a chance they will remain in effect? And so the answer to this is that needs and desires hearings will still be available. They're not going away. We just are trying to avoid requiring them for applicants when they're not necessary. So this will always be a tool available when there are issues that cannot be worked out prior to application. However, our data that we've looked at, over 95% of our hearings the last few years have been unopposed. And so again, that is money that our applicants are spending to hire an attorney to represent them in a hearing where no one's objecting. And so we're looking to streamline that process, make it a little less intimidating, and hopefully cut down on the time and money it takes for those applicants to get their businesses started.
All right. Next in the queue is One Chance to Grow Up. I'm going to promote you to a panelist, and then you should be able to unmute yourself. And if you want to turn on video, you can as well.
Good afternoon. My name is Hanny Lastly, and I'm the Executive Director for One Chance to Grow Up. And I just wanted to give a shout out to the corporate sponsors of 420. This will now be the 4th year in a row that the corporate sponsors agreed that 420 is not for individuals under the age of 21. While I'm pretty sure that's not a city enforcement issue, we really appreciate that partnership to keep little kids that are in strollers, toddlers, and then of course, vulnerable teenagers out of 420, and anything that the rest of the folks that are listening to this call could do to encourage your customers to, and just remind them of that 420 is for adults only. And we appreciate the partnership. And we have seen some measurable success on this. And while 420 this year is on a weekend, it's especially critical that this become a really strong behavior change for our community, especially on a school day, because there were days that many kids would skip school to attend 420. So just wanted to give a shout out and thank you all for helping wherever you can.
Thank you, Henny. Next is Samuel Giles.
May I be heard?
Yes.
Okay. Yeah, my question is for maybe Mark Slaw, because I think that I'm not sure if it was excise and license or it was Dido that had a program that was to assist social equity with the needs and desires hearing, kind of offset those costs. Does your program or Dido's new program for technical assistance provide that assistance as well? Or I guess where does your program start and then kind of where does it end with the assistance for social equity?
Yeah, it's a great question, Samuel. So I do believe there is a Dido program that reimburses on the back end any fees paid towards a needs and desires hearing that you can apply for after the fact. And our program is certainly going to look at every case individually. Every social equity owner needs something different. So there's not necessarily that you're going to need needs and desires hearing, especially after this new rule change, which may very well stream 95% of those applications through so that we don't even have to pay for that, let alone get reimbursed for it on the back end. But if you need one and the budget is there, then that is something we absolutely would love to talk about and help with, depending on each participant. So if you have that in your business plan, you're anticipating that cost, and you're looking to apply for the program, those are the types of documents we're going to need to be able to see, make sure that we can calculate it on our end and that we're going to be able to pay for that and help you out with that. As you may or may not know, there's been a couple iterations of the Dido program. This one is a little bit smaller budget, but we're also tasked to help, 5 to 10 social equity applicants this year. And that's what we're going to try to do the best ability we got, doing what we can with what we have. I hope that answers your question.
Yes, thank you so much.
You're welcome.
All right.
And sorry, just one point on that. The hearing fund, I think that you guys are referring to is run out of excise and licenses. And so I can put the link to that in the chat. But the way Mark described it was correct in that it's a reimbursement of expenses. And that is also an area where the funding level is a little bit lower in 2025 than it was in 2024. But given the changes that we're making to hearings, we still anticipate that there'll be enough budget to cover those that apply, then that qualify. So I'll put that information in the chat.
Thanks for the clarification, Molly.
Mm-hmm.
And sorry, I keep messing up the link for the flow chart that I mentioned. I will get it right eventually. Apologies.
And we're going to send out a recap email after this, so don't feel like you need to gather a bunch of links from the chat. We'll put all the relevant resources into a bulletin. So make sure you're signed up for our marijuana info bulletin so that we can get all this information to you. All right, any other questions, comments? Feel free to type in the Q&A box as well if you'd prefer. And feel free to email us comments at exlpolicy@denvergov.org if you'd rather take some time to ruminate and read the ordinance, maybe go back through this recording. We'd love to hear your written feedback as well. Okay, I'm not seeing any other hands raised or any other questions in the Q&A. So I think we can go ahead and wrap up a little bit early. Any closing thoughts, Molly or Erica?
I'll just mention, one, just a big thank you to Erica and Abby and Kelly for the work done on this presentation and pulling all this information together and the really thoughtful changes to the marijuana code. I think there are some really good changes that focus on both social equity as well as, efficiency and process improvement. So kudos to them on those changes. And then if you do have future topics you think would be important for marijuana industry check-ins or quarterly, regular times for us to get together, feel free to send those to the EXL policy email as well, and just general questions as well. So thanks to everybody for attending today. All the information will be posted online and sent out, and we look forward to hearing from you over the next couple of weeks as this ordinance goes through council.